speed limit was I doing, officer? The officer is trying to pull me over, talk about I was reckless driving, while I'm on US 1 doing the same speed limit everybody can doing.
On May 7, 2025, Officer Dre K, Applebaum of the Port Saint Lucie Police Department in Florida, initiated a traffic stop on a white Mazda traveling northbound on US. Route 1 clocked at 83 miles per hour in a posted 5 miles per hour zone. The stop escalated through a prolonged refusal to exit the vehicle, a reckless driving arrest, a DUI investigation, and a formal civil rights complaint, all captured on Officer Applebaum's body camera, footage obtained through the Port Saint Lucie Police Department. Viewer advisory. This video contains footage of a physical removal from a vehicle and verbal statements of a threatening nature, presented for educational and legal analysis purposes.
I wasn't.
No, but you can put your car in park and step out of the car.
I am, but why can't I argue
Get out of the
phone?
car. Step out of the car.
I'm gonna make a phone call.
No, you're going to step out of this car.
I am, but I'm going to make a phone call.
Okay, step out of this car.
Okay. But why?
Now.
Why?
Because I'm giving you an order to step out of the car.
But why are we giving me an order to step out of the car?
You can get out of this car on your own power, or I'm going to assist you out of this car.
Conversation on the phone.
Step out of the car.
Why?
Step out of the car now.
I will. Can you give me a second?
No. You are stepping out of this car
Why can't you give me a second?
now. Because I gave you a lawful order. Step out of the car.
Give me a second. Give me a second. Did Andre Menace call you and tell you to pull me over or something?
No.
Okay, so
your reckless behavior and driving is why I'm pulling you over.
I was right behind the
You're doing 83 miles an hour in a 45-mile-an-hour speed zone.
I was behind regular traffic. I was literally in between traffic.
I'm giving you one last opportunity, and now I'm going to tell you what happened.
Close your lights on.
Okay. I'm going to tell you what's going to happen. You're either going to step out of this car on your own power,
over or somebody else.
No, I intentionally pulled you over. I have stopped you for a lawful reason. I've given you a lawful order to exit this vehicle. If you choose to refuse that lawful order, I'm going to assist you out of this car. If you resist, I'm going to tase you.
Door.
Step out of the car.
I shouldn't have even opened my door for you. You should respect that alone.
Okay. This is your final opportunity. Step out of the car.
White. Like, let's be for real.
Okay, you're under arrest. Step out of the car.
Arrest for what?
Reckless driving and refusing a lawful order.
I wasn't reckless driving.
Yes, you were. Step out of the car.
Call your sheriff.
I'm sure they're on their way.
Yeah.
Step out of the car.
No. And
I'm going to explain this to you. When that next unit gets here, I'm going to pull you out of this car.
And I want to see your sheriff. Because now
I don't work for the sheriff's office.
You're doing too much. No. You're not taking me to jail for what?
You're under arrest for reckless driving.
Under arrest for what?
Reckless driving
on US 1, doing the same speed limit. What's your name?
It's Officer Applebaum.
Officer Dre.
No, it's not.
Officer Dre Applebaum. Officer Dre K Applebaum 926. I am thinking about Adriana. I gotta be there to pick her up. I gotta pick my daughter up at her daycare by 6 o'clock. How am I gonna do? I don't know how I'm gonna do that because this motherfucker is over here trying to take me to jail for doing some imaginary, unlawful speed. But you can't even go faster than what the traffic is doing on US 1. So how the am I speeding?
Okay.
Are they speeding?
This is your final opportunity. Step out of the car.
Can anybody speed?
This is your final opportunity. It's a lawful order. I'm a Florida certified police officer giving you a lawful command. Step out of the car. Final chance.
Certified police officer. Why are you? What the officer? I'm not even resisting. I'm not even speeding or nothing.
Stop.
Stop.
What the f is this? What the f is this?
Stop.
You didn't even read me my rights. I ain't even do nothing.
12-9-3-10-9.
I have not done anything wrong. My daughter has to be picked up by 6 o'clock at her daycare.
Yes, no, units for clear.
What are you arresting me for?
Come back over here.
What are you arresting me for? I didn't do anything.
Come back over here.
I didn't do anything. I have to pee. I didn't do anything, and I have to pee.
Do you have anything on you?
No, and I have to fucking pee.
Cool.
How are you speeding in this traffic? How are you speeding in this traffic? How are you speeding in this? How am I? You cannot do this. You cannot do this. You can't do this, bro. You're not even reading me my rights. I didn't do anything wrong to get arrested. You didn't even tell me what the I did to get arrested. What are we doing?
Sit in the car.
You didn't even tell me what I did to be arrested.
Sit in the car.
What are we doing?
Sit in the car.
No.
Sit in the car. Sit in the car.
All right, man, listen, you're about to get tased.
What are we doing?
You're sitting
What
in
are we
this car.
doing?
You're about to get tased.
Sit in the car.
You're about to get tased.
For what?
Get in
I
the
didn't
car.
even do anything.
Sit in the car.
I didn't even do anything. How am I speeding in the traffic? Officer Applebaum?
You were doing 83 and a 45.
What?
You were doing 83 miles an hour and a 45 mile
I
speed
was
zone.
doing 83 miles an hour.
Yes, ma'am.
Okay.
And then as I try to catch up to you, you start cutting in and out of traffic without signaling.
All the officers was after me. Oh, you're just the only one that supposedly caught me speeding. From all the way from fucking Melaleuca. Yeah. You're the only one from Melaleuca. Drenton Circle, Melaleuca. I've been doing the same fucking speed. I grew up here.
Okay.
I graduated from fucking St. Lucie, West Centennial. I know that I make lights change at night when you flash your lights. I know these streets. This my motherfucking shit. Okay? My streets. Ain't no fucking way you gonna sit here and tell me I was speeding. And you're the only officer that ever caught me in my whole life. I'm 32 years old. I grew up here.
Okay.
Don't fucking do that. Because you're not gonna win that. You're not.
I'm going to read this to you so you have an
I don't
understanding,
want to
okay?
hear any of that.
You have the right to
should
remain
not
silent.
be
Anything you say can be used
detained.
against you in court.
I should
You
not
have the right
be
to talk to a lawyer for
detained.
advice
I
before
should
we ask you
not
any questions and have him or her present during questioning if you wish.
Because you do not
If you
have
decide to answer questions
a
now,
lawful reason
you will still have the right to stop answering at any
pull
time
me over.
until you talk to a lawyer. You also have the right to stop answering at any time until you talk to a lawyer.
Reason to pull me over. You don't.
Do you understand the rights that I've explained to you?
Okay, Applebaum.
Do you have any questions about the rights that I've explained to you?
Dre, I'm gonna make sure the judge speaks to you.
Having these rights in mind, do you wish to answer my questions at this moment in time?
I'm not answering shit.
Awesome.
The threshold question is whether an officer may order a driver from a lawfully stopped vehicle.
Get out of the car.
The Supreme Court answered that definitively in Pennsylvania versus Mimms in 1977. The court held that once a vehicle is validly stopped, ordering the driver to exit is permissible, as a matter of course requiring no additional justification whatsoever. The Mimms court balanced the de minimis intrusion to the driver against the officer's safety interest in avoiding a roadside interview with a suspect seated inside a vehicle. That balance has never been overruled. The exit order here was categorically lawful. The subject's repeated refusals generate an independent criminal offense. Under Florida Statutes Section 843.02, resisting, obstructing, or opposing an officer engaged in the lawful execution of a legal duty without violence constitutes a first-degree misdemeanor. Because the exit order itself was lawful under Mimms, each refusal satisfied the elements of this statute. The underlying stop rests on Florida Statutes Section 316.192. Reckless driving is defined as operating a motor vehicle with willful or wanton disregard for the safety of persons or property, traveling at 83 miles per hour in a posted 45, nearly double the speed limit on a multi-lane U. S Highway satisfies that standard as a matter of law. The subject's argument that surrounding traffic was moving at equivalent speed carries no legal weight. Florida courts have consistently held that the unlawful conduct of other drivers provides no defense to a reckless driving charge. An officer is not required to cite all violators to lawfully cite one. When the officer introduces the threat of a taser, the governing standard is Graham versus Connor, decided by the Supreme Court in 1989. That case established that the reasonableness of any use of force or threatened use of force must be judged from the perspective of a reasonable officer on the scene, not with the benefit of 20/20 hindsight. Graham directs courts to consider three factors: the severity of the crime, whether the subject poses an immediate threat, and whether the subject is actively resisting or attempting to flee. After more than a dozen direct orders ignored by a subject remaining inside a vehicle, a less lethal warning is not per se unreasonable under that framework. However, Graham also requires consideration of whether de-escalation options were exhausted before the force threat, providing the specific speed 83 inches of 45 earlier in the encounter rather than near the point of arrest may have changed the subject's calculus. This is an area where the tactical analysis diverges from the legal analysis. The Miranda advisement administered at approximately the 7-minute, 43-second mark of the footage satisfies constitutional requirements under Miranda v. Arizona, 1966. The advisement must contain 4 elements: the right to silence, the use of statements against the suspect, the right to counsel, and the right to appointed counsel, if indigent. All 4 elements appear on this footage's audio. The subject's response, "I'm not answering shit," constitutes an unambiguous invocation of the right to silence. Under Bergwis v. Tompkins, decided by the Supreme Court in 2010, law enforcement must scrupulously honor an unambiguous invocation by ceasing all custodial interrogation immediately. The officer's acknowledgement and cessation of questioning is legally correct. A critical distinction applies here. The Fifth Amendment protection against self-incrimination extends to testimonial evidence. Field sobriety exercises, by contrast, are non-testimonial physical demonstrations. The Supreme Court addressed this directly in Pennsylvania v. Muniz in 1990, holding that standardized physical sobriety tests do not implicate limits. The DUI investigation could lawfully continue despite the invocation. The DUI investigation is initiated on 3 independent articulable grounds: a clear odor of alcohol from the vehicle,
What are we doing?
visible empty containers, and the subject's own voluntary admission to having been at the beach. Under Florida statutes, section 316.193, driving under the influence requires proof that the subject was driving and was under the influence of alcohol to the extent that normal faculties were impaired or had a blood alcohol level of 0.08 or higher. Florida's implied consent framework under section 316.1932 means that any person operating a motor vehicle in this state has already implicitly consented to chemical testing upon a lawful DUI arrest. Refusal to submit to testing carries administrative consequences independent of the criminal charge, including mandatory license suspension.
I can smell a clear odor of alcohol coming out of the back of this car right now, and there's empty containers inside of that car.
That
Okay.
was hours ago, though, at the beach and all. Do you want to do a trust test?
A trust test? I don't know what that
Whatever
is.
the f they call it. I've never been pulled over for what the f.
Well, I suspect that you're under the influence of alcohol right now.
Try it then.
I'm asking if you were, will you participate in roadside field sobriety
test?
test?
And let's do the testing. That's the law, ain't it?
Are you willing to
So
participate in
let's
this?
do it.
All right, just sit tight. We're gonna go somewhere else.
Somewhere else where?
We're gonna go to our station. We're gonna do it.
Here. Why you gotta take me somewhere else?
Because you already fought with us once. I'm not taking you out of handcuffs out here. We're gonna go to a secure
You
location.
can do it right the fuck here. There's 2 lines on the road. I'm looking at right now. Like right in front of my car. What's the problem?
There's a
You're not
perfect
taking me
area at our
nowhere
station.
secretly. I'm sorry to tell you that. If you DCF is gonna be called soon. My daughter's gonna be taken. I'm gonna have a vengeance. I'm gonna most likely lose my life for bombing y'all shit up and trying to kill everybody. So what are we doing? What is he talking about? Talking about I'm speeding. You don't know what the speeding is in a Mazda M3. Suck my dick! Go pick up my daughter, bitch!
Okay. Before you get out of the car.
Oh, what are we doing? Because I see you got gloves on.
Yeah.
Yeah.
We're here for you to participate in roadside field sobriety exercises.
And what?
For you to do what you were calling the truth test. It's called roadside field sobriety exercises. That's what we're here for.
Well, we could have done it right where we were, and you could have let me go so I can go pick up my daughter.
Right.
On time.
So we're going to walk in here.
Okay, let's do it.
Hang on.
Okay, what you need to pull me from the back, let's do it. Because the quicker, the better I can go get my daughter. I don't want to hear anything other than you can be released and I can go get my daughter. Because I didn't do nothing wrong.
If at any point in time you start resisting,
I wasn't resisting you in the first place.
Okay?
I wasn't resisting you in the first place.
Step out here. We're going to go in here.
Okay. So obviously, what are we doing?
There's a camera there, there's a camera there, and there's a camera there. Alright? This whole area is recorded, we're not even recording it.
What are we doing? What are we doing? And then now we're gonna walk the line. Go ahead.
Let's come down here. I'm gonna start down here. As I explained.
Like this. 1, 2, 3, 4, 5, 6, 7, 8, 9. And then turn around.
As I explained.
I don't remember how you explained the turn around, but I'm just going. 1, 2, 3, right? That's how it's turn. 4, 5, 6, 7, 8, 9. We made it 9 and not 10.
You're going to put your toe out in front of you so your foot's parallel to the ground coming here. I want you to look down at the tip of your raised foot and count out loud. 1001, 1002. You understand?
No.
What's confusing?
I can't even say the alphabet backwards. Can you?
I didn't ask you to do anything backwards.
1001. 1000. To 1000 what?
No, I said to stop. It's not unreasonably long time.
Okay. Until you're ready to get me a DUI. That's what you're doing. Alright. 1001. 1002. 1003. What am I counting to? 1000 what?
I'll let you stop. Do you have any questions about what I'm
I just want to know. I'm just ready to go. 1001, 1002, 1003, 1004, 1005, 1006, 1007.
Put your foot down, don't start it. Do you have any questions?
I already said no.
Begin.
1001, 1002, 1003, 1004, 1005, 1006. 1007. Well, I see 1000 before each number. 1008, 1009, 1010, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 1030. Are we still moving? 31, 32, 33,
There you go.
34. Huh?
Relax.
I thought you said I lost. I said I lost what? I was for the game.
Don't do anything until I tell you to start, you understand? When I tell you to start, I want you to estimate 30 seconds in your head. Start.
Close my eyes now. Okay.
Close your eyes.
Out loud.
No. Hang on, I'm gonna start. Are you ready?
Mm-hmm.
Start. Keep going.
Okay, well I heard movement, so I'm going to
Let's
try.
start.
So we're going to have to start that over. I heard movement. Okay.
Are you ready? You need me to explain anything again?
No, just don't move. With my eyes.
I know.
Okay.
Are you ready?
Yes.
Start. Bring your head back.
Bring my head back.
Yes.
Like this.
Perfect.
Okay. With my thumb out? You said?
As I described. Bring your head back.
Okay.
Right.
Am I supposed to?
Bring your head back. Left.
At this point.
Bring your head back. Right. Bring your head back.
How the fuck is this
Right.
if you're drunk or not? I am
Close your eyes.
like
Right.
this is retarded. I'm gonna have to come back with some rules for y'all because this is ridiculous. What are we
Close your
doing?
eyes. Bring your head back. Right.
And put my head back.
Yes.
Okay. My head was back the first time. Next.
Bring your head back.
Okay. Next.
Left.
Okay. Next.
Second one for 2 minutes.
Why? What are we putting your name for? Was that not the left hand? What do you think? Okay, so why are we putting your name
So
for?
I'm still on the neck for a while, and then I'll follow that officer to somebody's going to use it.
I couldn't use the bathroom before I put the handcuffs on?
You can, but there has to be human loss right here.
Is there what am I possibly do in the bathroom with both of y'all right here though? I could have used the bathroom just now.
Our policy says you don't have to leave here.
Okay, so I'm sitting here until they come. What are we doing? And then why are we being handcuffed again?
You are under arrest for driving under the influence. The next step in this is I'm going to request that you submit to a lawful test of your breath for the purpose of finding alcohol.
Why didn't you just do the thing of breathalyzer right now?
Because it's not how this works. Are you willing to submit to a lawful sample of your breath for the purpose of determining alcohol?
We already did all this shit.
Yeah.
Okay, so did you ask me if I was willing to do that before we did it? No.
It's not how this process works.
Okay, well, my process is yes.
The subject's statement that she will most likely lose her life for bombing y'all shit up and trying to kill everybody requires independent statutory analysis. Under Florida Statutes Section 836.12, it is a second-degree felony to make a written or verbal threat to kill or do bodily harm to a law enforcement officer, where the person making the threat had the apparent ability to carry it out, and where the threat caused a reasonable fear. The legal question is whether this statement constitutes a true threat or an expression of frustration. Florida courts apply an objective standard, whether a reasonable person receiving the communication would interpret it as a serious expression of intent to commit violence. The statement is on camera, is specific in its reference to officers present, and was made in proximity to a recent physical confrontation. These factors weigh toward criminal threat territory. This is ultimately a prosecutorial discretion question. The NHTSA field sobriety battery consists of 3 standardized exercises: horizontal gaze nystagmus, walk and turn, and one leg stand. NHTSA research places the combined accuracy of all 3 tests at approximately 91% when properly administered. Each test individually, walk and turn at 68%, one leg stand at 65% is weaker in isolation. A procedural issue arises from the relocation of field sobriety testing to the station. Under Rodriguez versus United States, 2015, a traffic stop may be extended when officers develop independent, reasonable suspicion and alcohol indicators of violation. However, defense counsel will argue that the time elapsed between initial stop and FST administration may have affected the subject's blood alcohol level in either direction. Additionally, the time estimation exercise administered as a supplement to the NHTSA battery is not a standardized validated test under federal guidelines. Its inclusion introduces evidence that defense counsel can effectively challenge as lacking scientific foundation. Officers are advised to adhere strictly to the 3-test NHTSA battery in DUI investigations to protect the prosecutorial integrity of the case. The subject's civil rights complaint that Officer Applebaum failed to request her name and identification before initiating arrest does not state a viable constitutional claim. Florida Statutes Section 901.15 authorizes a warrantless arrest for any misdemeanor committed in the officer's presence because the officer personally observed the 8, 3-mile-per-hour speed. No identity verification is a legal prerequisite to the arrest. Florida does not have a general stop and identify statute requiring a person to provide identification absent an independent basis. However, under Hebel versus 6th Judicial District of Nevada, 2004, where a state does have such a statute, a demand for identification during a lawful Terry stop does not violate the 4th or 5th Amendment. Florida's framework here does not trigger that analysis the subject was under custodial arrest, not a mere investigative stop. At the time of this analysis, the disposition of charges reckless driving under Section 316.192, resisting without violence under Section 843.02, and driving under the influence under Section 316.193 remains unconfirmed through public records. A potential threat charge under Section 836.12 is also unresolved. Case status should be verified through Lucie County court records prior to publication. Officer Dre K. Applebaum receives a beat. The traffic stop was constitutionally grounded under Wan versus United States. The exit order was lawful under Pennsylvania versus Mimms. Miranda was complete and entitled. The right to silence invocation was immediately honored under Burgess. The DUI investigation was initiated on articulable grounds. The deduction comes from 2 areas. The taser threat arrived before the officer articulated the speed information that may have de-escalated the encounter, and the failure to initiate the stop with a license and identification request created a procedural gap that contributed directly to the subject's resistance. Emanuela receives a D. The exit refusal is the central legal failure of this encounter. Pennsylvania versus Mimms is unambiguous. There was no lawful basis to refuse. Each refusal constituted a chargeable act under Section 843.02. The threatening statement is the second serious failure. Regardless of emotional context, a statement referencing bombing law enforcement officers in close temporal proximity to a physical confrontation is not constitutionally protected speech under Brandenburg versus Ohio. It is potentially a second-degree felony. One decision was legally correct, the unambiguous invocation of the right to silence under Bergwis versus Tompkins. The Port Saint Lucie Police Department receives a B+. The department's accountability mechanism, Sergeant Vega's proactive recorded callback to address the civil rights complaint, reflects institutional transparency. The DUI protocol was procedurally grounded in Florida law. The deduction is for the inclusion of a non-NHTSA supplemental test in the FST battery, which creates an avoidable evidentiary vulnerability, and for the absence of a second officer during the initial high-tension roadside phase. 3 lessons. First, Mimms needs no explanation but stating the speed early prevents escalation. Second, FST consent loses prosecutorial value when testing is delayed or not. NHTSA exercises are added. Third, emotional distress does not shield threatening statements from criminal exposure. The right to silence invocation was the only correct decision the subject made. Let us know if there is an interaction or legal topic you would like discussed in the comments below. Thank you for watching. And don't forget to check out our second channel, Street Bodycam, for more police interaction and courtroom content.